Good morning, everyone. Happy Tuesday. Good morning. Good morning. How's everyone doing today? It is Voters Day. Make sure you get out and vote. Election Day. I said Voters Day again, Election Day. But good morning, everyone. It's good to see you all. Make sure you hit the thumbs up on the way in. We got an interesting one, folks, as always. A very interesting one for you all today. As you can imagine, pretty sleepless night last night, tossing and turning, but to be expected. And it was all worth it because what a wake up it was. What a wake up it was. Hey, Belle, Starlight, Mr. Blue, everybody, good morning. Oh, they're my favorite, Lydia, but I don't like the new, like, hydro weird one. I don't know, it, like, heats up. Granny the Night Owl. Isn't that insane? Thank you, Pika. It's interesting news. I'll tell you that. It's interesting news. As I wrote in a community post, in case anybody did not get the alert to come join us this morning, need a good laugh after watching grown adults turn lawsuits into soap operas? Don't miss my upcoming stream where we'll be putting the absurdity of these legal games on full display. From the ridiculous claims to the dramatic contradictions, it's going to be equal parts jaw dropping and hilarious. Grab your cup of Nancy and come laugh as we break down the madness and remind everyone that common sense still exists somewhere out there. And I'm very happy to say that it does exist within my attorney. Major shout out to him because he don't play no damn games. Matter of fact, he likes to play the games the others are playing, and he does it better, and that's always a beautiful thing. Brandy Wine, thank you so much for the super chat. As you can all imagine, I'm sorry, with them filing the brief and what I have going on in Oklahoma, and with the declaratory judgment, um, these things cost. So if you are able to help in any way, it is sincerely and deeply appreciated because this sucks. GM Lovely, great news. Fingers crossed. Member for 3 months. Thank you so much. Bayou Babe, yeah, it's going to be interesting. But we have to build up the audience first because we're not going to jump right on in. I will start with yes, they did file their brief. Anybody want to guess at what time they filed their brief? 11:46 p.m. They filed their brief with 10 minutes left on the clock because they play these petty, stupid games because that is what they're used to doing. Proud Mimi, thank you for asking. If one of my mods could drop my Cash App, I'd greatly appreciate it. That's the type of games that these people play, right? But it's exactly to be expected with these type of people. And don't think for 1 minute the courts don't recognize that. Pretty in Pink with the 5 gifted memberships. Thank you. Yeah, because this has all been nothing more than a game to them. That's all it was. That's all it is. And again, the courts recognize these type of things. They're going to see that and they're going to know that these guys are playing some sort of game. But I'll tell you what did happen. Their game backfires. So let's jump right into it. Everybody ready? You guys got your Nancy, your whatevers? Let's jump right into it. Thank you again, Pretty in Pink. Granny, I clicked the wrong one on the poll. Do support you 100%. There's no wrong answer on the poll. I set it up on purpose, but thank you. Thank you, Crackerjacks. Well, you're gonna hear the brief and you can all decide who you think wrote it. I can't tell you who wrote it because I don't know. I can just tell you as oh yeah. Frenchie Mom, welcome. Thank you so much for becoming a member. Yeah. All right. So I will not be putting it on the screen because, to be honest, I don't like when people take my documents and I don't like it. So I will not have it on the screen for that reason. Um, they're not publicly available yet, so you can wait until they are, or you can listen to me talk about it. And by doing these live streams, it helps me to fight the litigation I'm in. The revenue of this stream, the super chats, the memberships, it helps me to be able to afford this. So it's yeah, yeah, poetic. Full of heart. Member for 8 months. Good morning, Granny and Melons. Thank you, Full of Heart. Good morning to you. It is actually very unusual, Tara. Oh, thank you, Helen. We like to be equal opportunity here. It is very unusual, Tara. What do you mean it's not unusual? In what world is it not unusual? Most people don't file it last minute in case they make a mistake, in case it doesn't get through the docket. There's many reasons people don't wait till last minute. Attorneys don't wait till literally the last minute to file something. Can you direct me into a example of where you say it's not uncommon? I mean, they've had 5 months now to submit this brief, and they wait till literally minutes on the clock to submit it. It's a game they're playing. That's all right because your comments always add up to do something like that, and it's very obvious. But if you think that's, it's not smart because again, that you can mess up on a header, you can mess up on the spacing, you can mess up on something that makes it not go through the docket, and then you miss the deadline. But I won't take a non-attorney's advice to say it's common because any attorney I've ever dealt with will say otherwise, and I've dealt with too many at this point. Standing with you, Granny. Thank you. Be nice. Try it. Starfire, welcome to the MFers. Yeah. They've had plenty of time, yes. Yeah, you guys won't see it because it's not on the docket right away. So I know people have been like, I'm checking the docket and I don't see it. Well, you're not going to. You don't, it comes through us first, then ends up on the docket. So anyway, we're gonna get into it. So they filed their brief, like I said, 11:49, and I really don't even need to read all of it because it's as you can imagine it to be. But I will read parts that particularly stood out. So they do what they're supposed to with the statement of jurisdiction, all of that. There's quite a few lies in here, like that one of the defendants posted Nick's parole officer's phone number, which never actually happens. Um, to be quite honest, I'm going to put it this way: their brief is mediocre at best, is full of errors, and the only reason we will read it is because somebody else will eventually anyway. Um, but it'd be much easier to read you my attorney's response because he responded immediately. And he points out all their issues, of course. So their reasons for claiming their merits for an appeal is funny. One, they claim that the anti-SLAPP is a special motion, is basically not recognized by Supreme Court yet, which is, funny. Years that should be given to the judge. What do you mean? I'm sorry. Shauna, wow, thank you so much. It is. It's always a trick question, James. So they said that the trial court abuses discretion and denied appellants a fair opportunity to oppose by refusing targeted discovery authorized by 42 PA. Now, here's the thing. So within this, they're saying that they asked for very narrow discovery, which was to ask us about our podcast. They wanted our YouTube earnings. And what else did they say? Let me get to it. But which is not true because if you go back and we pull up the transcripts to the anti-SLAPP hearing, the only thing Lasniak said he wanted discovery on was to ask us about our broadcast, which he admittedly had hundreds of hours of in an envelope. So, and that's not the way it works. Like the person who's during a slap motion, they would have never got our earnings. It would have been denied immediately. They would have never gotten them because they have no place to have our earnings. So that's one thing that they kind of so they're lying in here saying that they asked the judge for narrow scoped discovery, which is not true. Which is not true at all. Again, that's not what they asked for. You can pull up the transcript and you can hear it. Now, unfortunately, you can't reference the transcript because they didn't attach it. Then they claimed and weakly argued that applying the anti-slap here violated Articles S10C because the legislator's special motion procedure intrudes on the Supreme Court's exclusive authority over practice and procedure. So they're actually trying to say that the anti-slap is harmful to the Supreme Court, which is ridiculous because many states adopted it. So that's just stupid. Ellie, thank you so much. Frenchie Mom, thank you. They then go on to say the trial court erred in applying 42 PA before that section became effective under Act 72's express condition precedent. Supreme Court promulgation in Pennsylvania Bulletin. So their whole argument is that the anti-slap has not been recognized by Supreme Court, which again is a weak argument. The trial court abused its discretion and denied appellants a fair opportunity to oppose by refusing targeted discovery authorized by, local procedure. Again, if we pull up the transcripts, which I will, you will see that the reason that was shot down is because during a anti-slap hearing, it would be us that could ask for discovery, not them. And the discovery he was seeking, he held in a envelope. So, right, Shadow, because if you bring forth litigation, you should have proof of your claims, not go, fishing, trying to find them. Which is exactly what was pretty much stated. Actually, let me pull up the transcripts to show you what I mean. Should be quite interesting to everybody to seek over these again. Give me just a moment to see if it comes up. Dang it. Every time I open this one program, it freezes everything. We are frozen, my friends. Frozen again. All right, there we go. We got rid of that. We'll have to pull it up another way. No, well, he was actually correct. So they had hundreds of hours of podcasts, but he did have a 23-minute video of me sitting on his laptop ready to be shown. And that's what he's referring to there. That's what he was referring to there. But give me 1 second. I know that they also put on Twitter that they requested oral argument, which I'll be honest. I would be up for that. Like it would be entertaining to hear Lesniak orally argue in front of Superior Court against two very competent attorneys. I'm looking for here it is. All right. Let me get it for you all. 1 second. I'm sorry, I'm a little frazzled today. I didn't get much sleep, as you can imagine. But I haven't. It's not just because of this. I haven't been getting much sleep. Um, all right. Here, I have where Nonsense and I actually read it. The transcript.
All right. So I'll hear
Wait.
argument. I guess we'll start with the movements. I'll hear argument.
Thank you, lip locked.
As you know.
Your Honor, if we can, before you hear argument,
Yeah.
Nonsense.
Yeah.
the plaintiffs are asking for a continuance per the law that allows for limited discovery.
Uh-huh.
So that's Lasniak. Nonsense is speaking as Lasniak right now. This was his request for discovery that he is grossly misrepresenting to Superior Court. Okay? He's lying about what he was seeking on discovery.
We're asking that, Your Honor, because when we filed the complaint, the exhibits were digital, as you can imagine, Judge, because there are YouTube channels.
Uh-huh.
Office of Social Support would not accept digital exhibits, and so we are waiting for service to provide the digital exhibits. According to court administration, about 2 months ago, service hadn't been effectuated on one of the 2 defendants yet.
Had or had not?
Had not.
We're going to
Even
get
though
there,
we served
barbecue.
them with the sheriff's department. I got that because I contacted court administration to try and get this listed for the motion
I know,
to
barbecue.
amend the
Martucci
complaint.
filed.
I know that's not before Your Honor today, but Your Honor has the right to entertain a continuance request so that we can provide the digital evidence. We can have Mr. Martucci on the record attempt service
Accept
service on behalf of his client because it has not been accepted according to the civil court administration.
Listening back, I wish Nonsense did not read in that voice because it's hard to understand her. It was fun then, but now I'm like,
Administrator, Miss Bumpgard, because somehow the sheriff's service could not effectuate correctly either the motion for preliminary injunction or the complaint. I'm not sure, Judge. I did reach out to both counsel. Mr. King did not provide.
there we go.
Did provide.
I can't read like that. I can't plug my nose and read like that.
Yeah, it's okay. Go ahead. That was good though. That's gonna hurt.
Well, I can't even breathe. I'm like, whoa. Mr. King did provide an affidavit and signed it stating that his client has been served. Mr. Martucci instead submitted an email saying,
yeah, let me fix the closed caption. So first, Lasniak tried arguing that we shouldn't have the hearing today because he didn't have proof of service despite serving me with the sheriff. You can never forget the stupidity of that one. I mean, who says that? We didn't have proof of service, Your Honor, although we had her served by the sheriffs and it's on the docket. That's the type of oral argument this guy has.
This is ridiculous. It's been served. And that's it. That was not enough for Miss Bumgardner. We need something that shows Miss Granny's watching has been served.
Is there an issue on service? Now here's my attorney. Judge, there's no issue. The sheriff served my client on November 18th. It's docketed. The sheriff's return of service was docketed right after. Okay. There is no rule that I have to provide an affidavit of service to plaintiff's counsel when I'm representing a defendant. In fact, there was prior counsel for Miss GW at the time with regards to this. So there's no issue with respect to service. So there's absolutely no issue. There's never been an issue. It's been served. This is fabricated nonsense.
It is not, Your Honor.
All right. Well, so the sheriff served. The defendants they're not contesting service.
Now they're not, Judge.
So they've been served.
But I didn't know that until today.
What an idiot.
Right.
What an absolute idiot.
Excuse me. I sent you a letter. I sent you an email that stated we don't have to sign a proof of service.
That's literally how my attorney spoke during the hearing. He was angry.
The sheriff served her. That's sufficient. The sheriff hated it to her. He filed a return with this court. That's service. You look at the docket. That's service. And at no time in any communication from me or prior counsel did you get an email saying we weren't served. Okay, well, in fact, your client was. Hold on, they're saying.
Hold on. I need to look for the actual part. where they asked for discovery after their attempts at stating they weren't served wasn't sufficient. They then do the argument for, oh, well, we need discovery. All right, here we are. Oh, it was right there. I'm sorry. I jumped the gun on myself. I thought it was right around there. So here's the question of service that they're lying about on their brief.
That obviously I have to have an oral argument unless I extend that time period to allow for discovery for good cause. Correct, Your Honor. Okay. Or for good cause. So what kind of discovery do you need, Mr. Lasniak?
I have the discovery to hand to defense counsel. I believe it would be relevant.
You hear that? I have the discovery to hand to defense counsel. That's what he stated. So when he states otherwise in his brief, you are lying to the superior court. And of course, they didn't attach this, so the court can't reference it.
To them to have the exhibits and the discovery in this case and to continue the continuing course of action. So we're asking the court for a short time to provide that discovery. It is hundreds of hours of digital.
He wanted to provide us with discovery. There are hundreds of hours of digital broadcasts that are publicly available to all of you.
Digital evidence, Judge, that I have on thumb drives that Office of Social Support would not provide.
It's supposed
And
to be
even-
judicial support.
Oh, sorry. Thank you.
Thank you, Sami. Welcome.
Ugh.
23 months,
I'm-
girl.
No, it does say social, but it should be judicial. Why so fast? All right, we'll slow it down. Sorry.
Are we going too fast?
Yeah.
Hundreds of hours of digital evidence, Judge, that I have on thumb drives that the Office of Social Support would not provide, and even the 21st century would not accept. I could not put it into a document form because it does not exist in a document form. It is, in fact, digital evidence of YouTube, as Your Honor stated, but this has to do with podcasts that in which this information and the information came out. So we're asking the court a chance. We're asking the court a chance to do that as well as any other discovery that may be needed in this case for this oral argument. I understand, Your Honor. This is, the last minute. But again, we didn't know.
They like to wait till the last minute on everything, don't they? They love to wait to the last minute of everything. So at oral argument, suddenly Joseph Lasniak wants to do discovery. But guess what? My attorney served discovery on their clients and they never abided by it. Matter of fact, Brittany J said that she was being harassed by my attorney because he served discovery and or whatever they're called. But yet here they are at oral argument of months of leaving their docket vacant. They now suddenly want to serve discovery when we're actually having a hearing?
Until Mr. Martucci stated that service had been rendered. And that, that we're trying.
And that's the type of lawfare games that they played. Emailing my attorney asking for proof of service. And my attorney said, why would I ever provide you with proof of service? Look on the docket. These are the type of games they play. That's what makes it lawfare. That's what makes it frivolous. That's what makes it baseless, that they're games.
Trying to get this listed for the motion to amend the complaint, Judge, because we're asking for, and I understand the motion to amend is not before Your Honor, but the amended complaint needs to be decided before a slap motion can be.
That's the other thing they put in their complaint, in their brief, that they had a amended complaint sitting on the docket that was not addressed by the courts. They claim that she never addressed it, but you're going to hear that she does address it. So again, they're lying to superior court, but that is why they left these transcripts off of their brief.
Filed because the complaint is.
Why do you need leave? I saw there was a motion for leave. Why do you need leave?
Here's the judge
Just
acknowledging
because,
it.
Your Honor, we're asking to change the complaint and by the complaint information.
You don't need leave. Has there been an answer?
There was an answer to it. Yes,
And that's the whole point, because once there's an answer, once answers are filed, you don't need the court's permission to amend your complaint. Or opposite. I don't know. We'll get to that in a minute.
did not file. We were waiting for service. And you would believe that.
So really quick to inform you all, they did not need to request permission from the courts to amend. They simply could have amended. That's big to remember here. They never needed permission from the court. They could have just amended. So she goes on to say, there's been an answer to the original complaint. which of you filed an answer to the complaint? So an attorney says, no one has. That means there are preliminary objections, Your Honor.
Right?
Okay. And okay. So if there are preliminary objections,
That I had 20 days to file. I understand that, Judge, but I did not do that because service hadn't been effectuated according to the court administration.
What a
Mr.
fucking
Lasniak,
liar.
you don't need, there's no answer. There's preliminary objections. Miss Barbecue, I guess, filed a complaint. Here's my attorney. And I joined those, Your Honor. Okay, so now here comes Mr. King. Your Honor, now the judge, you file POs and then you can just file an amended complaint.
Right.
And we were
So imagine later filing on your brief that one of the problems is the judge never ruled on your request to amend when she didn't need to rule on your request to amend. It is nobody's fault that Lasniak was incompetent and wasn't able to pull up a docket and see that the sheriff that he paid to serve me served me. That is his job to know if I'm served or not. At no point did my attorney reach out and say, hey, you never served my client. The only reason they tried, this is games that they pull. Put a 1 in the chat if you see the games that they pull. Should we keep note of them all? From filing at 11:49 to pretending to not know if I was served or not, despite paying the sheriffs to serve me and seeing it on the docket, to coming into the courtroom that day and asking for discovery, but never once filing to submit discovery against us, ignoring my attorney's request for discovery against your clients. These are all nothing more than tactics to stall the courtroom because that's what these people do. It's sick.
but we were waiting for service to be rendered, Judge, or a
Fucking
decision
ridiculous.
being made.
So this is the judge basically saying you didn't have to wait for us. What are you talking about? Okay, so here comes Mr. King, and this man's very tall, very well. I'm gonna enter my Mr. King. Judge, the plaintiff could have filed an amended complaint at any time with respect to Miss Barbecue because there is the first issue that we ought to get out is who are the lawyers in this case?
Yeah.
Because this gentleman added Mr. Castor, who I've known for many years, as counsel on this complaint. And that's part of what's going on here.
That's another part of the games they played. So let me get up the other part where Lasniak then explains his request for discovery and what it entails, which is absolutely ridiculous. All right. Oh, it's right here. Again, I'm jumping my own gun because I'm impatient this morning. But it is right about here.
About any claims whatsoever. This fellow, Dog the Bounty Hunter from TV fame, is added to try to intimidate these two poor women that had to put up with this stuff. But if the court would take the time to read the brief filed by Ballard Spar, it is a terrific brief. It says what the purpose of the statute is. And what the purpose of the statute is to stop this kind of nonsense. And discovery is more nonsense added to an already egregious scenario that's before this court. And it's this time had to become out any people I dare. They're the rules of the court. You need to read the ridiculous. The amendment lies the validity of this particular slapp statute that we're here on today. This stuff about discovery and amending a complaint, the amended complaint that's offered is simply to add more people into this already ridiculous action that's been brought. This action, if the court has had the opportunity to read this complaint, this 300 and some paragraph dialogue that's before the court cannot stand on any aspect of a complaint that's required to be filed under the rules of civil procedure. Every aspect of this complaint is improper. There isn't a single properly pled allegation. There are people identified as plaintiffs in this complaint, Your Honor, with no allegation about any claims whatsoever. This fellow, Dog the Bounty Hunter from TV fame, is added to try.
I'm sorry that I confused you all with my poll. There is no wrong answer, and that's the irony of it. But I appreciate you all just hitting the thumbs up. Thank you so much.
To intimidate these two poor women that had to put up with this stuff. But if the court would take the time to read the brief filed by Ballard Spar, it is a terrific brief. It says what the purpose of the statute is and what the purpose of the statute.
Sorry to pause again, but James Steele, I appreciate you asking. PayPal is better because YouTube takes such a percentage of super chats, but I appreciate either way. Thank you for asking.
Is to stop this kind of nonsense. And discovery is more nonsense added to an already egregious scenario that's before this court. And, well, except that legislation, the statute, actually allow discovery when a motion such as yours is made. If in your discretion you see that's something reasonable, what of 350? What's the discussion?
And that gets brought up in their brief, saying that it is up to the judge's discretion to allow limited discovery. And the judge used her discretion on that date to say no.
Discovery, which is why I asked Mr. Lasniak, what's the discovery that you need?
Some information, Judge, as to the
Welcome,
basis
Leslie.
of their podcast.
Here we go.
So we have podcasts, Judge, going all the way back to the beginning of October from these two defendants regarding my clients and statements made about my clients. Things like calling them a pedophile, calling my client's probation officer, and making complaints, and all sorts of other outlandish accusations and defamatory accusations. Making things like
So they wanted discovery to ask about our podcast that he had in an envelope. And I would love to this day to show any proof of myself calling anybody, let alone Seth Rogers, the P word.
From these two defendants regarding my clients and statements made about my clients. Things like calling them a pedophile, calling my client's probation officer, and making complaints, and all sorts of other outlandish accusations and defamatory
I would love proof of any of those claims. They never happened.
accusations.
That's not discovery, Your Honor. Now, my attorney, that's not discovery. You just said
It is, because
you just said that you have hundreds of hours of exhibits and you need discovery. That's not discovery. And the claims you make under RICO, defamation is not a predicate act for.
Did anybody hear Lasniak bring up that he needed our income with that discovery? Of course not. So let's get back over to their brief where they do try to lie to the courts and state that that's what they were seeking during discovery. There's several issues with what they wrote, but I'll go ahead and just, they argued that the slapp is goes against Supreme Court. Of course, people like this would be against the anti-slapp because it harms them in every way. Where your average person is grateful and thankful for something like the anti-slapp. So that's what all this is. Denial to leave to amend. So they wrote issue 6 concerns the trial court's dismissal of the case with prejudice, despite appellants having a pending motion for leave to amend their complaint. Ordinarily, when a claim is dismissed on preliminary grounds, Pennsylvania procedure favors allowing at least one opportunity to amend unless amendment would be futile or inequitable. In this case, it would be futile. There's no reason to do it. The decision to grant or deny leave to amend lies within a trial court's discretion, which is exactly what she brought up. It is up to whatever. This court has made clear that a trial court is given broad discretion in evaluating amended requests, and its ruling will not be disturbed on appeal absent a showing an abuse of that discretion. The standard review for issue 6, therefore, is abuse of discretion. In conducting this review, however, the court remains mindful of the liberal amendment policy. Pennsylvania appellate courts have repeatedly emphasized that Rule 1033 must be interpreted to allow amendments at any time, including before, during, and after trial, in order to decide cases on their merits other than on technicality. Accordingly, leave to amend should be freely granted unless doing so would violate a positive rule of law or unfairly prejudice the opposing party. A trial court's failure to allow an amended absent such consideration may be deemed manifestly unreasonable and hence abuse of discretion. Well, that will never fly because, as you heard, the judge acknowledged that they did not need the court's permission to amend. And she simply was not allowing them to amend because we are now at a slapp hearing. They sat this vacant on the docket for months. I want you all to remember that. They abandoned their own filing. It wasn't until the judge set a date for the anti-slapp that they finally responded to their own filing that sat on the docket collecting webs. It's ridiculous. Here we go to issue 7. Finally, issue 7 asserts the trial court erred by dismissing a lawsuit without first developing a proper factual record or holding an evidentiary hearing contemplated by 42 PA. Whether the trial court complied with the statutory procedure or instead prematurely terminate the case is a legal issue, not a matter of discretion. The appellate court therefore applies a de novo standard of review to issue 7. In practical effort, this challenge resembles a claim that the court granted a form of summary judgment without adhering to the procedural requirements were mandated by law. So again, they're just ignoring the fact that anti-SLAPP is now law. They then reference their docket, and this is what they write. As described by the trial court, the matter relates to online podcasts hosted by defendant Truth and Sang, in which hosts and participants discuss true crime investigations. The court summarized the complaint as a certain defamation and related tort claims, among others. The operative complaint was filed October 18th. The docket reflects the complaint filed October 18th, filed the same day by an entry titled preliminary injunction, and a petition to amend filed November 6th. On December 23rd, defendants filed a motion to dismiss, briefing, and related entries continued through February. Defendants moved under Pennsylvania anti-SLAPP statute by special motion to dismiss. The court scheduled oral argument after referral on February 12th and held oral argument on February 18th. A 77-page transcript of the February 18th proceeding was filed on February 27th. But note, they did not attach it. And they are expecting the Supreme Court to pull up the docket to get the information they need instead of supplying the Supreme Court with the information they need, which is exactly why they failed, which is exactly why they're incompetent. But we'll get to that. On March 21st, the plaintiffs filed an emergency petition, the restraining order that Brittany claims they never filed. They sure did. The court entered 2 separate orders. 1, dismissal and fees order, and 2, a mercy motion order denied. Plaintiffs filed a notice of appeal on May 12th and the records transmitted on May 15th. The docket reflects a Rule 1925A opinion filed May 15th. The Superior Court docketed appeal, blah, blah, blah. Plaintiffs filed their statement of matters complained on of appeal on June 3rd, preserving 7 issues challenging inter alia the court's reliance on procedures. Its classification of the broadcast as protected public expression, discovery and evidentiary rulings, denial of emergency relief, blah, blah, blah. This is where they lied to the courts on what they were seeking. They lied to the courts that we had ongoing doxing, harassment, and threats, none of which came from myself. So how dare you try to hold it against me? And then here they go, denial of leave to amend. Appellants had a timely motion under PA 1033. Pennsylvania favors liberal amendment absent prejudice or futility. The court dismissed without addressing or analyzing an amendment, contravening Rule 1033 and controlling precedent. Remand is required. They did not. She acknowledged it. Although the court held oral argument, it had failed to apply requirements to evaluate the motion on summary judgment record. They're trying to say that we don't fall under protected speech because they're saying that we sell goods on here. So now they get into discovery. Discovery and case management rulings are reviewed for abuse of discretion. Even assuming arguendo was operative, the court misapplied its plain text. UPEPA, which is the anti-SLAPP, stays proceedings upon filing a special motion, but prefers a safety fail. The court may allow limited discovery if specific information necessary to it is showing is not otherwise reasonably available. So I want you all to read this part. This part's major. Okay. So the court may allow limited discovery if the specific information necessary is not reasonably available. You all heard what Lesniak wanted for discovery. Lesniak wanted our broadcast that he admitted he had in his envelope. So it is readily available. In parallel, allows a non-movement who cannot yet present evidence essential to justify opposition. You want to be you're the movement to obtain time for affidavits, depositions, or other discovery. Together, these provisions ensure the immunity and exclusion questions are decided on a fair summary judgment type. Now, this is where they lie. They say that they requested narrow discovery tailored to the statutory issues. They wanted authentication and complete copies of the broadcast recordings at issue, which again, Lesniak waved around in an envelope. They wanted our platform monetization and solicitation data relevant. They would never get that, ever. And they never requested it. And communication bearing on knowledge of falsity or reckless disregard. So again, they're lying to the Superior Court. Because when Lesniak was asked during that hearing what discovery he sought, he said our broadcast. He never said any of these other things, which again is why they didn't attach it. So you can basically just see this is how ridiculous. And then they add that counsel also pro-offered a 23-minute contextual audio. The court declined to consider and stated would accept no supplementation. Right. Because you had months. You had months to submit the exhibits, and you never did. The court further read on record in a manner that the cabin discovery away from plaintiffs then proceeded in an argument-only posture under the statute's timetable. That's exactly what an anti-SLAPP hearing is. It's an oral argument. So, yeah, you guys basically say it. These rulings foreclose the very mechanism creates to avoid one-sided adjudication under discovery stay. Here they go again, that they were not allowed to get limited discovery, but that was not what they sought. They sought to get the podcast that they had in their hands. So let's move along, because my attorney can tell you all exactly where these guys FA'd, FO'd. Kim, thank you so much for the donation to the Give, Send, Go. Y'all ready for this? Because y'all know my attorney wasn't playing last night. We waited months for them to file, and he put the pen to the paper and filed. He filed application to quash the appeal. Hold on one second. Thank you guys so much for the PayPals and Cash Apps. I got to make sure I have my volume a little bit up in case my... All right. You guys ready? Let's get some emojis in the chat. Make sure everybody's awake. Attorney and how they file. Let's get some emojis in the chat to see an actual attorney at work. Let's teach them what an attorney looks like. RLA, have a great time at the meeting. Should we hit him with some won't back down? We need our Tom Petty in the background. Let's get it. Right now, my attorney's going to take them to law school, baby. Let's hear it. This matter was brought before this court by appellants, wherein they appealed a lower court ruling dated April 17th, 2025, granting myself and Barbecue's motion to dismiss under 42 PA, which is the Anti-SLAPP Uniform Public Expression Act, Pennsylvania Anti-SLAPP statute. It should be noted, the appeal being posited before this court is as baseless and nonsensical as the filing which brought about myself and Barbecue's motions to dismiss under Pennsylvania's anti-SLAPP statute. To be clear, the appellants levied their action in the lower court without basis in law or a speck of evidence to support their poorly drafted, vapid claims. Tellingly of incompetence, Appellants assert a cause of action under criminal statutes and a civil action, while also asserting a cause of action claiming a predicate act, defamation, for instance, of RICO, when no such predicate act exists under the federal or state RICO statutes. It is clear the appellants have little to no grasp of the law, or for that matter, the procedural rules of any court. For example, number 6, the appellants believe and assert they needed leave of the lower court to amend their initial filing. Amazingly, after preliminary objections were filed by appellee Barbecue and then joined by myself. Footnote 1. It is not for the undersigned to educate appellants as to why seeking leave to amend was unnecessary. Good point. 7. The lower court painstakingly had to address what was found to be anemic, untimely responses to the motions to dismiss under anti-slapp statute and a for abuse complaint, which resonates their lack of the minimum legal competence to support claims, which were without a doubt wrongfully levied in the lower court, now wasting the time of this court. Even more distressing was the fact that appellants could not follow the local rules of court and simple requests from the lower court. Amazingly, the appellant submitted to the lower court a concise statement of matters complained of on appeal. Make no mistake, the lower court did not request appellants to file a concise statement of matters complained of on appeal. These appellants continued their rogue, do as they well please conduct, snubbing their distorted appendages at this court. In that regard, on or about May 21st, this court exited a docket and statement. The appellants were given until June 4th to file their docket and statement. Appellant's docket and statement had not been filed with this court and was noted by myself to be 26 days late on June 30th. Appellants failed to offer good cause for their tardiness in not filing their required docket and statement pursuant to PA Rep 3137. Moreover, the appellants did not request an extension of time to file the docket and statement or provide a legitimate excuse as to why their docket and statement or an application for extension of time to file the docket and statement was forthcoming. The failure to file a timely completed docket and statement may result in dismissal of appeal. As a result, on June 30th, I filed an application to quash the appeal for failure to comply. Barbecue then joined the application to quash the appeal. On July 10th, instead of responding to the joint application to quash the appeal, appellants filed an application for extension of time to file a brief without prior notice of either of appellee's counsel. On August 1st, the court quashed the appeal. On August 5th, appellants filed an application to reinstate their appeal. Both appellees filed an answer to the appellant's application to reinstate the appeal, pointing out the lack of good cause, the clear disregard for the rules of court, and the utterly clear mendacity of the excuse used as a reason to reinstate the appeal, as the appellant's counsel was continued to handle matters despite asserting his practice was put on hold as he acted as a caretaker for his unfortunately sick father-in-law. So he lied. On August 22nd, this court granted the application to reinstate. On the same day, appellants filed their docket and statement. On September 22nd, this court issued a briefing schedule. Appellant's brief was due on or about November 3rd. Appellants filed their brief at 11:46 p.m. on November 3rd. You know why that's important to point out? Because it's a game they're playing. The brief of appellants has a myriad of issues that fail to comply with the Pennsylvania rules of appellate procedure. This application to again quash the appeal of appellants follows for failure to comply with PA Rep 2111 and preclude oral argument under PA Rep 2188. You want to know where they effed up? Let me tell y'all. Let's look up what PA rule Rep 211 is. They never submitted the judge's opinion or the trial records. Therefore, Barbecue and I cannot respond to their brief. They left out a major step in the process of a brief. Okay? Because number 2 of it states that they are to attach the order or other determination in question. They never did. So therefore, Barbecue and I cannot even respond to their drivel because they never attached the ruling. It is an epic fail. There's not a statement that issue of statements of matters complained on appeal was not orders, nor did they attach the opinion. There is no reproduced record attached. Arguments are not properly developed. We cannot even respond because they failed so bad. How's that 11:49 deadline looking for you now? Play stupid games, win stupid prizes. The brief of appellants includes, but is not limited to, the following issues: failure to attach the opinion of the lower court as an appendix, failure to set forth the statement that the statement of matters complained of on appeal pursuant to PA 1925 was not requested by the lower court, although these appellants filed one with the lower court. And the brief makes note of a reproduced record but fails to set forth notations to the reproduced record pages being referenced, nor was an actual reproduced record filed. So let me pull that up really quick because he gives me a footnote. Number 3, footnote 3. If a statement of matters complained of on appeal was ordered by the lower court, then the statement of matters complained of on appeal needs to be attached to the brief of appellants. In this case, the judge never asked them for one, but they filed it anyway. It is frivolous bullshit from them. No, I think it was. I bet you it was Nick and Hong playing games. Hence why Hong said we asked for oral argument, because in my opinion, that's who's been the scrivener of this entire filing. Going forward, PA Rule 2111 sets forth the following: the brief of the appellant, except as otherwise prescribed by these rules, shall consist of the following matters, separately and distinctly entitled, and in the following order: the statement of jurisdiction, order or other determination in question. Not just them taking this snippet of it, but attaching it entirely. Statement of both the scope of review and the standard of review, statement of the questions involved, statement of the case, summary of argument, statement of the reasons to allow an appeal, argument for appellant, a short conclusion stating the precise relief sought, the opinions and pleadings specified in graphs P and C of this rule. In the Superior Court, a copy of the statement of errors complained of on appeal filed with the trial court pursuant to PA 1925B, or an averment that no order requiring a statement of errors complained of on appeal was entered. So they should have told the courts, the Superior Court, yeah, this is filed. That the judge never asked for that. There's the certificate of compliance required by PA 127 and 2135D. Opinions below. There shall be appended to the brief a copy of any opinions delivered by any trial court, intermediate appellate court, or other government unit relating to the order or other determination under review, if pertinent to the questions involved. If an opinion has been reported, that fact and the appropriate citation shall also be set forth. There's a reason they're avoiding attaching the judge's opinion. So wrong. Pleadings. When pursuant to 2151, original hearing cases, The parties are not required to reproduce the record, and the questions presented involved an issue raised by the pleadants. A copy of the relevant pleadants shall be appended to the brief. Brief of the appellant. In a superior court, there shall be appended to the brief of the appellant. A copy of the statement of errors complained of on appeal, filed with the trial court pursuant to 1925B. If the trial court has not entered an order directing the filing of such a statement, the brief shall contain an affirmation that no order to file a statement of errors complained of on appeal was entered by the trial court. Litigants in Pennsylvania must comply with procedural requirements in order for their appeals to be heard by the appellate courts of this Commonwealth. No doubt this court can find a litigant waives their claims when an opposing party has successfully argued the litigants waive their claims through a procedural default. Under 2188, if an appellant fails to file his designation of reproduced record, brief, or any required reproduced record within the time prescribed by these rules or within the time as extended, an appellee may move for dismissal of the matter. If an appellee fails to file his brief within the time prescribed by these rules or within the time as extended, he will not be heard at oral argument except by permission of the court. In this case, the brief of the appellants was filed on November 3rd, and although the brief references the reader to a reproduced record, amazingly, not really. Can we take a moment to acknowledge that snark? Missy Lou, thank you for hitting the thumbs up. He says, amazingly, not really. Because it's no different than what they've done this entire time. There's not one time in this entire filing where these guys have actually followed procedural rules or rules of procedure. The reproduced record pages are not noted in said brief, nor was a reproduced record filed in conformity with the rule. Notably, the appellants did not request an extension to file their reproduced record, nor was an extension granted by this court. In that regard, Rule 2151, considerations of matters on the original record without the necessity of reproduction. General rule, an appellate court may, by rule of court, applicable to all cases or to classes of cases, or by order in specific cases under subdivision of this rule, dispense with the requirements of a reproduced record and permit appeals and other matters to be heard on the original record, with such copies of the record or relevant parts thereof as the court may require. If leave to proceed in form of papyrus has been granted to a party, such party shall not be required to reproduce the record. When under the applicable law, the question presented may be determined in whole or part upon the record made before the appellate court, a party shall not be required to reproduce the record. An appellate may, within 14 days after taking an appeal, file an application to be excused from reproducing the record for the reason that the cost thereof is out of proportion to the amount involved or for any other sufficient reason. Ordinarily, leave to omit reproduction of the record will not be granted in any case where the amount collaterally involved in the appeal is not of proportion to the reproduction costs. The reproduced record shall be served and filed not later than the date of service of the brief or 21 days from the date of service of the appellate's brief in advance form if the record is being reproduced pursuant to Rule 2154, which means it's too large of a record. That's not the case here. They just didn't file. Reproduced records shall be deemed filed on the date of mailing in first class. Any supplemental or reproduced record shall be served and filed with the brief of the appellee. Appellants have not met the requirements or the applicable scenarios where the reproduced record would be excused from production and notation thereto to allow meaningful review of their claims. Notably, the reproduced record was not filed on the date of the filing of their brief. Furthermore, this is not a case that a large record exists. Also, while not on a substantive or procedural phase warranting a point for quashal, the brief of appellant's reference number footnotes, yet no footnotes seem to be present in circumstances. So at one point during their written brief, they reference footnotes that don't exist. They don't even put the footnotes there. These guys are geniuses. Next, PA 2111 requires the appellants to attach as an appendix the opinion of the lower court. Despite a through search of the brief of appellants by the undersigned and a review of the filing in toto, no appendix containing an opinion of the lower court is present thereto. Additionally, the brief for appellants fails to comply with PA 2111D. Make no mistake, the Pennsylvania Rules of Appellate Procedure make it clear, and Rule 2101 conforms with requirements. Briefs and reproduced records shall conform in all material respects with the requirements of these rules, as nearly as the circumstances of the particular case will admit. Otherwise, they may be suppressed, and if the defects are in the brief or reproduced record of the appellant are not substantial, the appeal of other matters may be quashed or dismissed. So their whole argument is based on the transcripts of that hearing and the judge's opinion, neither of which they attach for the Superior Court to reference or for us to reference. It's like insane. It's a gross waste of time. It's a gross waste of the court's time. The continual course of conduct by these appellants has remained as they are emboldened to do as they please, again snubbing their never-do-well noses at the lower court, this court, and the appellees, by failing to follow the rules set forth by the courts of this Commonwealth. Where I respectfully request this honorable court grant her application to quash the appeal forthwith and other relief deemed proper and just. Let's read that again. The continual course of conduct by these appellants has remained as they are emboldened to do as they please, again snubbing their never-do-well noses at the lower court, this court, and the appellees by failing to follow the rules set by the courts of this Commonwealth. They think they can just do things however they want. It is unbelievable. I don't know. I think like 5 a.m. Electro. 6:10 a.m. He submitted that. So if our filing goes through, which I'm not too confident it will, because Superior Court likes to hear things on the merits, but it will be noted. All of this will be noted by the courts. They will recognize that Lesniak claims he needed bereavement, but yet was practicing in other cases. They will recognize that they did not attach these things to their brief, making it almost impossible for us to respond to the brief. So even if they don't dismiss this motion or grant it, if they don't grant this motion, he also argued that they threw away their right to oral argument, which I understand that they are supposedly writing on X, proud of themselves that they sought oral argument. I wish I could get audio of their oral argument during the anti-slapp because it was nothing short of comical. I would love to see them argue in front of 3 judges this time. I know, Just Tracy. And again, it's because Superior Court likes to go on the merits. Prolonging all this via lies will be noticed and will be nicely compensated on. I hope so. It's going to be hard for us to reply with our brief, right? Filing false claims just to keep someone tied up in court is abuse, plain and simple. It's definitely grounds for abuse of process lawsuit, which is also a malicious prosecution. They have no merits. They never did. That's the worst part about all of this, is they never had merits for any of this. And I guarantee the other plaintiffs that are involved in this that have never had to worry about even a second of this are sitting over there comfortably living their lives as if nothing's going on because they have not been impacted by this. Right, it further validates why this is an anti-slapp. You wait till the very last minute on the clock to even submit it, like this is all a big game to you. I don't know. I mean, their filing was mediocre at best. They even admit here in their brief and their table of contents that they never attached the judge's opinion, which is crucial for the courts to have. Thank you, Sassy Hound. Like my attorney says here, there's no reproduced record attached. Arguments are not properly developed, nor is there a statement that issue of statements of matters complained of on appeal was not orders, nor did they attach opinion. Look at footnotes with no footnotes. Page 34, footnote 4, followed by footnote 1, but they don't actually put any footnotes in. Let's pull that up. Page 34. Let's see. All right. So on page 34, they sure enough have a footnote here, footnote 1, and they have a footnote here, 2. They have another footnote here, 1. They have a footnote here, 4. But there's no footnotes. No footnotes. So what are you footnoting? So for those of you who are unaware, a footnote is when they put this little number there. They're basically offering more context to what they just wrote. As you saw in my attorney's, an actual attorney's filing, when he put a footnote, here's an example. Here's a footnote, right? Number 1. So you scroll down to the end of this page, you can find his footnotes. His footnotes are further explanation to what he just wrote. So the fact that they put footnotes but didn't actually attach the footnote is another reason why these guys are, it's all such a game, right? And the saddest part is this all ruined the awareness of a missing child because these guys wanted their 10 minutes of fame and they didn't want us to interrupt their grift, in my opinion. And this is here we are. 5 months after their brief should have been due, they wait till the very last minute mark to file it. And then you didn't even follow the procedural rules of the courts while filing it. There is no actual audio from that court here, and I tried. And even if there was, you're not allowed to play it. Is that so they can say an error that footnotes weren't attached and get more time to refile? No. You don't, this isn't like lower courts where you can say like, oh, I made a procedural mistake. Please allow me to amend it. This is superior court. Can these lawyers be charged with conduct and falsely representing the court in paperwork? There are some options that I've spoken with my attorney about that can be done about all of this. Yeah. Do they get more time or are they in trouble? They're in trouble. They don't get more time. That was their moment. That was their big moment to respond, and they fucked up royally. If they would have filed this a week ago and did not attach the reproduced record, then they could have had a chance at asking for an extension to attach it, but they waited until literally the day of. I don't know MJ's life. They can respond today. They can respond tomorrow. They can respond in 2 weeks. Oh, I know, Tracy. I heard Brittany's ridiculousness that I contacted her lawyer. I would love proof that I called your lawyer, Brittany. Brittany said the reason she called my lawyer was because Delaware County courts told her to. The only way Delaware County Court would tell you to contact my lawyer is if you told them you were not represented by counsel and you were going pro se. But unless you file yourself into the court to recognize you as pro se, you still can't contact my lawyer. So either which way you spin it, you contacting my lawyer proves without a doubt that you are not represented by counsel. I agree, Krama. She did, and she's trying to make them, right. I don't even think the courts can. I don't believe that the courts are going to tell her that, but I don't know. That's what she claimed, right? Let me see if I can find it for you, because it was kind of funny. Not going to lie. I was quite amused by her response. I was really amused by good old reality's excitement. All right, here we go. Let's hear it.
The new GW's allegations about you.
What?
What? Like you weren't watching. Shut up.
You haven't seen it?
No, what is it?
What,
you
was
called-
she sleeping? Did she just get woken up? It sounds like she was sleeping, to be honest, but hold on. Sorry, I don't mean to mute.
Her attorney.
About what?
You called her attorney.
Oh, yeah, I did. Sure did. I sure did call her
Look,
attorney.
Look, she admits.
Look at that. Look at reality. Look, she admits. That was the most awake I heard reality all night. Shocked by her own friend admitting to doing something that she couldn't deny. And I wish she would have tried. But how funny is that? Look, she admits. Reality's like, yay, give her a cookie and a gold star. She admitted it. She admits. I need one quick second, though, guys. I'm so sorry. Hold on. Don't leave. I got something else coming. Okay, I'm back. Tell me, reality didn't sound like a mother who's been working really hard to teach their toddler the harms of lying and the impact it has, and that the toddler finally admitted to something instead of lying. That's what reality sounds like here. It was the funniest thing I ever heard. Listen again.
Did. Sure did. I sure did call her
Look,
attorney.
Look, she admits.
Just like
Look, she admits. Yay! I'm so proud of my little toddler learning to finally admit the truth. Now listen to Brittany deflect, because that's Brittany's specialty, right?
Sure did. I sure did
What,
call her
Lucy?
attorney,
Look, she admits.
just like she called my attorney.
I,
Sure did.
I want proof I ever called your attorney. My little girl is growing up. I mean, this is the juvenileness of all of this. And then the fact that she right away deflects, just like she called my attorney. I would never call your attorney because I've been represented from the start of all of this. And people are like, maybe she means an RICO. No, she didn't, because they go on later to not even know how to pronounce Laziak's name. That's right. Good old friend Reality here doesn't even know how to pronounce her little toddler friend's attorney's name.
Exactly.
Exactly.
Yep.
I had to. I'm not. See, this is the difference between me and
There's many differences between us. Can I remind you all, this is how they should thank me. The chat should thank me for waking them up. And then look, comments about attorney will be deleted. This is how they were.
About you.
what?
It was a gosh damn snooze fest over there.
GW's allegations about.
Brittany even grunts. Didn't I tell you all that this girl is giddy to talk about drama? Literally giddy. She loves the drama, baby. Look how it woke their asses up with a quickness.
Single legal she does on a pay dubs. I'm not. See, this is the difference between me and G Dubs. I don't.
Notice she calls me G Dubs, like she idolizes me. G Dubs. This the difference between me and G Dubs. Like you gave me some type of street name because you fucking idolize me. G Dubs. That's like a nickname you give to a friend or something. I'm not your friend. I will never be your friend. So bizarre. Yeah, I heard that too, Chroma Chronicles. We're going to get into that. We're going to get into that. Like, I'm on some juvenile, oh, but she talks about me every day. I'm a goddamn adult. I'm an adult whose life you impacted on a level you will never understand. And if I want to speak about you every goddamn day, that's exactly what I'm going to do. You know why? Because I have the freedom to do so. If I want to talk about you now, get off this live and come back an hour later and talk about you some more, that's exactly what I'm going to do.
I'm not going to blast
right.
all of my legal stuff on a panel. That's not normal.
No, what's not normal is raising $8,000 and showing nothing being done with it. That's what's not normal. I love how she says that it's not normal to blast your legal stuff on the internet. When who's the one that blasted this legal stuff on the internet first? Can anybody tell me who's the first to bring 2 lawsuits that I'm in to the internet first? Them. They're the ones that put it on the internet first. So I love the fact that when it's not going in her favor, all of a sudden it's weird to bring it to the internet. All of a sudden it's not normal to bring it to the internet. Y'all sure felt it was normal when you were sitting on top of the world thinking you were going to successfully accuse us of RICO. You sure thought it was normal when you read Tony's filing again prior to me being served because you thought it was going to be successful. I love how it was all normal then when you thought it was going in your favor. But when nothing's going in your favor, suddenly it's not normal. What's not normal is to claim to have paid an attorney $8,000, yet we can't find his name on a docket anywhere as representing you. That's what's not normal. Well, tell me what's not normal. The same way you came on the internet crying people were calling your attorney, you don't think I'm going to come on the internet and tell people you called mine? Of course I am. What's not normal about that? Can anybody tell me? More importantly, it's very normal when I'm receiving help from my audience to fight these frivolous litigations. They deserve to have step-by-step updates to what's going on. You're the one not normal, collecting money from your audience and then not showing them a penny of where it's going. For anybody who's confused what my attorney's doing and if I have an attorney and what the payments are, his name's on a docket. You can find it. You can see the work he's done. Has anybody seen any work that Brittany's attorney's done? Don't tell me what's not normal. What's not normal is your goddamn breathing. Go to a fucking doctor. That's what's not normal.
No matter
It's
how
not
normal
normal.
y'all think it is that she does that, it's not normal to talk about every single legal
You're not
thing
supposed.
that happens.
Are you telling me that you calling my attorney is a legal thing that shouldn't be spoken about? You know what's funny? Go around the internet. You got Destiny in a lawsuit. He gives every single bit of updates in it. You got this other guy that people keep coming in the chat mentioning. They give every single update that's going on. You got Turtle Boy, who's in litigation, that gives every single update that's going on. The only people that are trying not to normalize it are people like you who are lying to your audience about where the litigation stands. See, I'm confident in where I'm at with this litigation. I have no problem presenting it to all of you. Brittany has a problem because she'd rather her audience remain blinded sheep and not know the truth of where we stand. Hell yeah, I'm angry. I'm tired of people saying, oh, you sound angry. You sound aggressive. Yeah, I am angry. Would any of you be angry? I'm fucking exhausted. I am so exhausted from all of this. And most importantly, I'm tired of this little fucking heifer sitting over there acting like she ain't doing shit. But she does talk about you and everyone else nightly. I know she does, but she's the freaking victim. So sick of hearing about how everyone won't leave her alone. Detest people playing that victimhood. Me too. Me too.
happens. It's not- Like, you're not supposed to do that
No.
shit.
Says
But
who?
yes, I did. For a very good
Listen to her adjust herself in the seat before she lies to her audience.
that
No.
shit. But
Mhm.
yes, I did.
Right there.
For a very good reason.
For a very good reason. So when I called the court clerk today and say, hey, did you advise a defendant in a case to contact an attorney? I'm going to find out, okay? Because you like to blame everybody around you for the stupid decisions you make. So we're going to find out.
And I was advised by Delaware County court to contact Martucci. So
No, we'll find
there's
out.
that.
We'll find out, Brittany. Don't you worry, Tuts. We will find out. I know. That's why I said the chat should thank me for waking her and reality up. They went from talking like this to suddenly wide awake, sitting herself up in the seat and everything. I appreciate that, Jason. We'll find out. They're not allowed to give legal advice. They're not going to tell somebody who's not even recognized as self-representing to contact an attorney. They're not going to do that. And again, the only way I can possibly see it being done is if you told them you were pro se. But again, you're not recognized on the court filing as pro se. So I doubt it. I doubt they said that. Why wouldn't you contact your lawyer and ask him what to do? Because you're not represented. And instead of admitting you're not represented, you'll gaslight and lie to everybody and deflect by stupid things like, Granny called my attorney. Anybody tired of this grown-ass, damn near 40-year-old woman hitting everybody with whataboutisms? We tired of that? Well, yeah, I drew on the wall, but they did it first. Grow up.
And I'll leave it at that. So
They more
GW can
harassing
go
you.
around, you know,
Listen to Reality
And I'll-
mumbling through her dentures out. Shut the fuck up, Reality. I am so tired of this lunatic acting like she has any forethought or any remarks that even matter. You're like a useless puppet sitting over there. Plaintiff's case is one long string of Richard relocations, delay, lie, act like victims, and treat the court like a game. Polite way to say dick move. Thank you, Kimberly. It certainly is, man.
I'll leave it at that. So
They more
GW can
harassing
go
you.
around, you know, pouting and crying or
Didn't I tell you all that they would say that I'm harassing her by knowing that she called my lawyer? And did you hear the useless puppet just say that? The useless puppet just said, more harassment. More harassment. Is it really, though, harassment, Reality? Are you a grown woman? The truth will be revealed. That's what you can't stand. That every single day I reveal the truth on your little buddy over there. The one who left you hanging on Halloween. What a loser.
that. So
They more
GW can
harassing
go
you.
around, you know, pouting and crying or bitching or I don't know what she's trying to do. Like,
Did I pout? Anybody? Did I pout? Did I whine? Did I bitch? No, we had a good old laugh at the idea of you being so fucking stupid that you would contact the opposing counsel. We actually found it to be so comical. There was no whining, pouting, or bitching. That's what you do over there, Toots, not me. That's what you do. We had a good laugh at it. Share your lawsuit docs once this is over. Absolutely, Purple. Thank you for the super chat.
But yeah, I did. And what about it?
And what about it? Did you get the email? That's what's about it. Did you get the email? Check your email. And what about it? And it is against procedural rules. It is unprofessional. Idiot. What about it? It proves again that you don't have an attorney. That's what it is. That's what's about it. That's why you're deleting your own chatters for asking about it. Because it proves, without a shadow of a doubt, that you did not retain an attorney for shit. His name is nowhere but on these C&Ds that weren't even properly written.
But she's making a big old deal out of it, of course. She always got to make a big deal out of all of it.
It is a big deal, Reality. Hey, Reality, what's your government name? Maybe I want to throw you in frivolous litigation. You can see what a big deal it is, Reality. Keep running that little muzzle of yours over there. I can't wait to your subpoena to court. I can't wait. Love to be a butterfly on your wall when you receive that document.
Bigger than what it actually.
She talks about me every day.
I know that, and she's.
You eat every time you're live. Why don't you go exercise? I'll talk about you again every day until I'm done talking about you.
She tries to say she doesn't.
Nah, I no longer say I don't because I fully embrace the fact that I do. If there's a cow that's going to lead me into a courtroom and make me spend a bunch of money, I'm going to milk it. Okay? All right, Reality? Maybe I'll dedicate a special stream to you tomorrow, Reality.
We don't talk about her every day. I just want to
No,
bring
ever.
her up, on the fact because
No, ever. They never talk about me. You sued me, bitch. You threw me in frivolous litigation, and then you sent me a C&D, and you threatened to take away my channel. Do you think I need you to speak on me for me to speak on you? I'm an adult, okay? I don't follow by your juvenile rules. And you do talk about me every day.
she gets under my skin when she goes on.
You know what? I take back. I'm not going to talk about you tomorrow, Reality, because I think you're special needs, okay? And I don't like picking on people that I don't feel are all the way mentally there. So I'll leave you alone, Reality. See. Put your dentures in next time you're on panel. Tell the other one to stop putting food in her mouth and entertain the audience that is before you. Stop relying on all of us to do that for you, okay? All right? And don't lick the windows, okay? She is fucking special, this one. She gets under my skin. Then don't fucking listen to me, you moron. How about that, Reality? If I get under your skin, then don't listen to me.
She gets under my skin when she goes on and on and on about things like that. And she was harassing.
She was harassing. Granny coming live and telling everybody Brittany called her attorney was harassing. Do you even know the definition of the words that you use? Harassing. And Brittany's over there shoving her mouth. Mm-hmm. Probably a second away from falling asleep. Mm-hmm. No wonder you have to go to the dentist. Jesus golly. Sitting there with a mouth full of fucking candy, falling asleep and shit as Reality talks about shit she don't even know. It was harassing.
They were harassing the attorney, Lindsay Knack, whatever.
Now we were harassing the attorney, Lizniak. Does anybody even know who that attorney is? Never heard of him. Lizniak. You don't even know the attorney that's representing your best friend? Lizniak. She was no, Reality.
Lynn's harassing the attorney, Lindsay Knack, whatever. Lynn's Knack. The attorney, Lindsay Knack, whatever.
Is it me or are these two slurring? And why didn't your friend Brittany help you pronounce that name? Is it because she's sleeping? Can somebody clap? Can we wake her up? Wake up, Brittany. She doesn't know how to pronounce your lawyer's name. Your non-lawyer's name.
Knack, however you say his name.
Lesniak.
Lesniak.
That's shameful.
That's
Mhm.
shameful. That's shameful. I can name a lot of things shameful, and that ain't going to be one of them. Jesus. Did people really listen to this shit?
They couldn't leave him alone.
We couldn't leave them alone. I hope you have proof of the
There's a
claim.
difference. That's all I wanted to point
Mhm.
out. You were
Yeah, they're the difference. They're, what are you even talking about? You two buffoons.
not harassing.
Nope, never.
The only thing being harassed right now is that chair. Holy hell, do you hear that thing? That thing is like literally on its deathbed. Listen to it. The poor chair.
You were not harassing.
Nope, never. Never have, never would.
The struggle is real. Actually, you did. Remember when you sat up there and you lied that my attorney seeking discovery was harassing you? And then you called him a back alley attorney. And then you said that he breaks kneecaps. Do you remember that? Anybody else remember that? I do. Yeah, I do. Stop talking about the lawyer Lint Snack. I know. Like, what was that guy's name again? Back to silence. Sorry, chat. Their excitement's over until
All
they
right,
get a
let's
new
keep going.
topic.
Listen, I'm going to say this one time. I'm not discussing my legal stuff.
You don't have legal stuff. You haven't responded to any legal stuff. You lied to your audience. That's why you're not discussing anything. Anybody remember Brittany up there proudly talking about, oh, help me defend myself. Help me raise $10,000 a month. Now all of a sudden she don't want to talk about it, right? You know, nobody wants to talk when the truth doesn't look pretty for them. I get it.
That
No.
period. I'm not here to do legal stuff. That
No.
period. I'm not here to do that. So
I'm not
No.
here to do that.
But I didn't want it to get like out of hand. So that-
Then one is she slurring, guys? Put a 1 in the chat. Are these two okay? I'm a little. It's a little questionable right now. I mean, I don't listen to reality a lot, so I don't know if this is how she always talks. But she don't sound right. They're slurring, right? Somebody else just wrote it. They're slurring. They're slurring, and no, I'm pretty sure Reality loses, not special needs. She has been neck deep behind the scenes helping Griffney. Well, there's something going on. Lots of ones, all right. But Truth and Karma says this is how she always talks. Oh, I don't know. I don't listen enough.
But I didn't want it to get like out of hand. So therefore I mentioned it.
How could it get out of hand, Reality? It is what it is. Your friend basically validated what we all already knew by contacting my attorney and not doing so via somebody representing her, and then further validated it by claiming that the courts told her to contact my lawyer.
But
If the courts told you to jump off a bridge, you doing that next? I mean, come on now.
we're not going to talk about any more of the legal stuff.
You should all continue talking about it because it was the only time you were awake. Whew, that was rough. How do people really? How does anybody tune in for that? To present all that evidence she claims she has, and she chose not to. She has no evidence of anything. She never has, and she never will, because most of the things that Brittany says are either exaggerated, fabricated, actual admittance to things that she has done, or the things other people have done that she tries to put on me. That's the truth of what happens here. Right, Reality brought it up, but then said we're not going to talk about it. That they're harassing. I might need to make a soundbite of Reality struggling to say Lasniak's name. I never heard somebody struggle that hard. Lie snack. Leisnack? They harassed Leisnack. They harassed him. Where's the 8K plus BJ? Because we all know she raised well more than 8K. I'll tell you that. I will absolutely tell you that. She raised well more. And then she's over there in a chat where people are being doxxed. But don't hold her to that. How many times has it been pointed out that any of us were in a particular chat? But when it comes to her, it's always rules for thee, but not for me, isn't it? It's always the way it seems to go. Even typing loudly like UGW, I wouldn't doubt it. Everything Brittany does. The funniest part is her telling everybody they're going to, all right, y'all, we're going to take a palate refresher. Trying to copy Jay. A palate refresher, anybody? Why are they always crying harassment and stalking when we speak our opinions? Because they can't handle them. You know the classic quote, you can't handle the truth. That's what she does. Did Ranger tell you stop using his name and stop lying on him because he doesn't represent you? Well, again, if he represented her, he would have responded to my attorney's email. And he didn't because he's not representing her. G-dubs. You know the difference between me and G-dubs? There's a lot of difference between us. And it certainly isn't only what you said. I know, Rhodey Gale. That's where she learned. BJ recently said, gives me self-embarrassment. Brittany doesn't have any self-awareness. I mean, even her friend Reality was shocked that she admitted to something. She admitted. See, taking ownership. Let's hear that again, because that part was funny. After Brittany's done playing stupid for a moment, then we get that part.
I had to.
Yeah, look, she admits.
I did. Sure did. I sure did
Look,
call her
see?
attorney.
Look,
Oh, see?
look, she admits.
Look, she admits. I'd be damn embarrassed if anybody ever said that after I admitted to doing something, because it proves how little she admits to anything. That her own friend got that giddy and excited. Oh, look, she admits. That giddy over it. Yeah. Palate refresher, she called it. She's going after Duchess right now. That's what she does. She has to pick on somebody. But anybody she goes after, just remember, when she starts crying, she's afraid for her life and her family and everything. No, you're not. She doesn't feel like she has to disclose where the money went. I don't understand that. She talks in circles about payments, but never movement forward in court records. Huge difference. Well, and it's ironic, right? That she had all those things to say about me, who's raising funds to fight against her, not to initiate. And yet she doesn't think that she should hold to what she herself said should be done in these situations. Right. There's no way she could deny it on Butter. But of course, they did what we said they would do. They would claim that by me knowing that, I'm harassing her. By my attorney telling me that she contacted him, I'm harassing her. They must be brainwashed AF to keep supporting a scammer. Well, I don't know. I heard that whatchamacallit left her, Brenda. Or that Brenda's at least, going into different chats. Easygoing person. Takes a lot to make me angry, mad. But I know for a fact I'd be fuming if I was Granny's shoes. All hell would be done, broke loose. Sometimes it's amazing I haven't lost it yet. But again, they filed and they did not attach the proper documents that need to be attached with their brief. So, like I said, the Superior Court could respond today and agree to our motion to quash, or at least stop them from being able to do oral argument, or they won't do anything with that. They'll allow them to go through, but when they make their ruling, it will all be duly noted because that's what the courts do. You're a strong woman, Jess. Keep you in prayer. Thank you. Brenda Sue and Brenda Stapleton. I think it was Stapleton. Thank you so much, Mittens. BJ was basically ignored for days while people spoke on Lauren. Next thing you know, she shares videos. Right, Kimberly. And brainwashed so much they don't care about their own damn time. Let her have all that dead air. Yeah, that was tough to listen to. Clue was at TRH in the video, Sebastian. Oh, good golly. Thank you, Steph. I'll take a look. Can you get a refund? Well, yeah, actually, there are things that people could do. I'm not going to tell you all what they can do because they can figure it out on their own, but there are definitely courses to take for sure. All right, let's take a look over here again. Hold on. I wish they would try. So everybody knows Froggy's hiding under the name Gray Dragon. A proud folks are found responsible for special disappearance, and she supports them. Oh, shut up. Oh, do you guys know that according to Froggy, every word of Britney's DV report was spoken by a creator? Halloween, because great. I agree with that, Nana. I honestly do think that's why she did it. I absolutely do think that's why. Because all these years of her being on here, she has never done that. Funny, when she got served, it was a nothing burger. Now she's calling your attorney. It was unconstitutional, right? Randomly, she's been awake the past couple of days. Was the thing you were waiting on yesterday, did they appeal or was it past deadline? I went over it earlier, Miss J. They had procedural mistakes in it, so we don't know what's going to happen. Like I said, usually the courts want to hear on the merits, but in this case, it's beyond obvious that these guys are not following court procedure and they're just draining it. Like the last sentence of this filing says, the continual course of conduct by these appellants has remained as they are emboldened to do as they please, again, snubbing their never-do-well noses at the lower court, this court, and the appellees, by failing to follow the rules set by the courts of this commonwealth, which is something the judge pointed out too. They never follow the rules of procedure. Yeah, I know, up to good. Is that something? What full thing runs with scissors? They were already warned not to. She can't spell constitutional. Well, I love these people that want to take away others' constitutional rights, but then cry for their own. Oh, you're talking about the DV. Sorry. Okay. I can't believe how far they've gotten in a very obvious anti-slap situation. Well, this is what I keep thinking, May. And let me know what you all think. I think the reason the Superior Court is allowing them to get this far, despite all their mishaps and the obvious frivolousness of this, is because it would be precedent setting, right? So the only way for it to become case law and be the first successful anti-slap under this new legislation is for Superior Court to judge it on its merits. And I think the Superior Court wants to do that. So when the next anti-slap is filed in PA, there is a guideline for others to use as an example. And this is, as Judge Eckel quoted, the perfect example of exactly what was meant to be stopped with this legislation. So I don't have much faith that they'll actually quash as requested in our latest filing, but they may say that Joseph Lasniak does not get to present oral argument because of his failures. Is a very slippery slope when you think you can do what you want at 11:49 the day something's due. Lisniak, how unbelievable. Proceedings set, and it is. I guarantee you any other anti-slap filed in PA will not be as bad as this case. No case could warrant the anti-slap more than this fake-ass RICO. And then to lie to Superior Court about the scope of discovery you requested, to lie that you have proof that people posted Nick's probation officer's phone number. Nobody I know did that, but let's think about that for a minute. Let me actually look. I wish I could. I don't. Hold on. I don't know. Watched a few minutes review of BJ's last night. Oh my gosh, when I thought I couldn't despise her more. Hold my mellow yellow. I know, Miss Kim. It sucks. It honestly sucks. Nick wanted people to call his PO. Well, let's be real. In their filing, here, I'll pull that up. In their filing, they say the fact that people called Nick's probation officer, or I'm sorry, they claim that because the defendant posted the phone number to Nick's probation officer, that led to strict restrictions being placed on Nick. Now, the fact of the matter is, because the Proudfoots or somebody around them contacted Nick's probation officer, that led to strict restrictions. It had nothing to do with me, or as far as I'm aware, barbecue. Because I sure never posted the probation officer's phone number. It had nothing to do with that. Answered in a negative by the lower court. See, they're cheating here. All right, hold on. Let's see where they put that. Denial of targeted discovery. Denied them a fair opportunity. Bullshit. And again, the fact that they didn't argue that during the slap, and they didn't even put the trial record that they're referencing for the courts. Because you think if the courts actually heard the trial record, which I just played for you of us reading out, and they see that Lesniak did not ask that for that type of discovery, you think they'd be happy that they just sat here and lied to them? They didn't never ask for channel revenue data. And not only that, but you would never get it. And if Lesniak wanted to do discovery, he had months to file for it. He never did. So they're focused on the fact that the anti-slap is not merely about speech. Okay, if you don't think so. Right here it says, the regime conflicts, which entitles a non-movement to obtain evidence essential to justify opposition before a depositive ruling. Here, the court refused appellant's discrete discovery and barred supplementation, then decided dismissal. Yeah, because you had months to put your exhibits on. You never did. The rules presume discovery subject to protective orders. Hear that, Brittany? Because you still claim you never filed a protective order against me, but I'm here to tell you, in your own brief, you admit to filing a protective order. That the inversion, all right, where'd it go? Yeah, they don't like the sanctions. Let me make this smaller. I wish I would have marked it before I came. And decided appellee special motions on argument only. It was a structural separation of powers error. Oh my gosh, reading this is actually kind of funny. They're saying because the administrative office of Pennsylvania courts did not put up a bulletin regarding the anti-slap, that is not actually in motion. So we're basically saying that we can't use the anti-slap despite the fact that it was voted into legislation in July of 2024. They're telling us that we can't use it. That's kind of ironic. They said because there is no promulgating rule, no letter of address, and no bulletin notice establishing an effective date. The effective date was the day that it was rolled in. What do you mean? They're trying hard with that one. This is a technicality. The General Assembly itself recognized Article V, allocations of procedural rulemaking to the Supreme Court, and built an activation gate to avoid separation of powers conflict. Until the court acts and notices publish, a procedural device is not in force. I don't think so. Here they go again. Footnotes without putting the footnotes in. The court further read on the record in a manner that cabined discovery away from plaintiffs, then proceeded in argument-only posture under the statute's timetable. That's how it goes. Okay, here it comes. They're claiming that during the court proceeding, because their side, their people, Froggy and them, called and claimed that we were live streaming the courtroom, that's proof that we were live streaming the courtroom. That is literally what they're saying. They're saying, hear me again, okay? This is important. Hellfire, thank you so much. They are claiming because they had people that support them call into the courts and claim that we were live streaming that day, that on its own is proof that we were live streaming. I kid you not, Jackie Blue. That is their claim. Right here. And again, they don't attach this. They don't attach the records to validate what they're saying. The court returned to the bench and stated, go back on the record. Live streaming of these proceedings, I don't believe is appropriate. A sheriff's deputy and counsel discussed the legality. The court described a second report of live posting in order to check of phones and identification of gallery attendees, which we all handed over, and there was no proof of live streaming because it never happens. And then imagine if we were live streaming. How does that endanger them? Courtrooms are live streamed all the time. How does that endanger them? The motion identified two ongoing dangers: doxing and targeted harassment. Appellants allege publication of private identifiers. The only person I know of who did doxing was Nick. Tied to calls to action that predictably trigger harassment and can escalate to stalking or physical confrontation. But yet all these months have gone by and neither of these things have happened, right? I mean, come on. Knock it off. Here it is again. Unauthorized courtroom record and broadcast. The motion sought narrowly tailored relief to halt recordings or dissemination of courtroom content and court-adjacent filming. That never happened. Right here. Here they go again, referencing something they did not attach for the judges to see. As an alternative, the court wrote that not one page, paragraph, or exhibit showed that a named defendant recorded or broadcast the February 18th hearing. There it is. You had your chance. You submitted your evidence, and none of it was sufficient. So what are you crying about? Take the L. That analyst was too narrow and legally demanding for preliminary relief. They're quoting the order, yet they didn't attach it. Narrow in error. The order focused on proving that a named defendant personally made the recording, while the motion also sought to enjoin solicitation, aiding, abetting, and reposting, or otherwise weaponizing courtroom source content, and separately sought anti-doxing relief. The court did not meaningfully address the doxing prong. Oh my gosh. Yes, Nick's doxing should be addressed. Put a 1 in the chat if you agree. Nick's doxing should definitely be addressed. Right here. Unrefuted in court facts. The court's own actions, interrupting proceedings over live dissemination, ordering phone checks, establish good cause to consider restraining further recording or dissemination. So because the court got a phone call that a live stream was taking place, they're saying that is enough proof that a live stream was taking place. Anybody else scratching their head on that one and rolling your eyes? They're claiming that alone. Again, nobody's phone showed any type of recording or live streaming, and yet they're saying that on its own is proof. The court could have fashioned a temporary order to halt imminent harms while the merits were litigated. There were no merits to litigate. That's what you're missing. There was never any merits. I'm glad that they wrote this, though, because maybe I'll copy this as I seek to hold Nick accountable for doxing me. Maybe I'll just copy this whole thing they wrote right here about doxing. Doxing, a term that Lesniak himself admitted he was not even aware of prior to this filing. Permits amendment at any time by leave of court. Pennsylvania policy is to liberally allow amendment to secure decisions on the merits. There was no merits. I was looking for the part where they bring up Nick's probation officer, but who knows where it is in all this drivel. Oh, here it is too. They're claiming that YouTube is a sale of goods. Then you would have to argue that the anti-slapp, which originally started for journalists to not be sued for their coverage of things, you would have to acknowledge that journalists sell their goods because what they sell is what they're putting out to the world. That argument falls on his face. How long is this filing? 55 pages. Any communication related to the sale or lease of goods or services. I'm not selling a service. Argued broadcasts were commercial enterprise. At the hearing, defense counsel acknowledged appellees received donations from people. When was that ever stated? Oh, here they go again, lying to Superior Court. Check this out. They're claiming that defense counsel acknowledged appellees received donations from people, therefore making us a commercial enterprise, but the donations from people was in regard to us raising funds to fight them in court. Characterized appellant's request relief as seeking to prevent defendants from raising funds. They stated that we were not allowed to raise funds to retain counsel. Anybody remember that? And they're now trying to misrepresent those two things. They're unbelievable. You guys are unbelievable. I can't wait till the Superior Court realizes how much you lied in this. Lesniak should be held accountable. Appellant specifically requested targeted discovery on a platform monetization to prove the conduct fell within. You never did. You never sought discovery on our monetization. We played it today. They never requested that. They're lying. Here it is. Targeted personal attacks and doxing directed at private individuals. Do you guys know that Nick the Hat's now a private individual? Nick has a frat suit who even put his alias and the title of the lawsuit is now claiming to be a private individual. He's not a public figure suddenly. Unbelievable. Appellant's pro offered that appellees posted a probation officer's phone number, urging followers to call. Show me proof of that. Show me proof of that. I've never done that. You will not be able to make a single thing showing I've done that. yielded thousands of calls, and leveled specific criminal accusations against private individuals. There he goes again, labeling one a molester and accusing another of being involved in the abduction of his own child. Proof. Where's the proof? Where's the proof of any of this? And again, they're not private individuals. They are all limited purpose public figures, every last one of them. But yet they're lying to Superior Court, calling themselves private individuals. I love that for them. That's why they didn't attach the judge's ruling, because she acknowledged how each single one of them is at most a limited public figure. Crucial, fact-intensive nuisance. No, that's not the way this works. These people are unreal. Right. He put his alias in the title. Nick Casafrasu, and then in parentheses, he put Nick the Hat. So they're lying to the courts and never distinguish between commentary on a public figure and targeted harassment of private individuals. You're kidding me, right? None of them are private individuals. Can you believe that they're lying to the courts this way? I mean, why am I shocked, to be honest? Why am I shocked? Nothing they do should shock me anymore. And never distinguish between commentary on a public figure. That's exactly she did. She distinguished all of you to be public figures, or at minimum, limited public figures. Because it was unprotected harassment. Can you fathom these people? YouTube is not a commercial six. Yes, like when Nick doxed me and my family members, OG Fish. And Lasniak responded back with the definition of doxing. Because at that time, Lasniak recognized that what Nick was doing was doxing. Threats from dog, right. I know, straight talker. Everything they're accusing us of is actually what they've done. It's sickening. The trial court's argument-only session where it refused to review pro-offered audio. Yeah, because you can't just... somebody has to teach Lasniak how to be a lawyer. Sorry. Like my attorney said, it's not his job to teach them the procedural rules. This is unreal. I think they're grasping to drag this out for as long as possible. Nick said in the beginning this would take years. Yeah, they did. I don't know about all of you, but I'm just tired of it. But at the end of the day, we have to fight it, right? No choice but to fight it. It's disgusting that people are able to lie this way. It's disgusting that these people would literally write in their briefs lying to the courts. They lied about what discovery they requested. They lied about being private people and not the fact that they are all public figures. They lied about us calling anybody, me calling anybody a molester. They lied about saying that we said that he was involved in the disappearance of his child. I never said that. And even if I did, I'm allowed to. Seth Rogers himself stated he is a suspect in his son's disappearance. It's not illegal to give my opinion if that was what I thought, but it never happened. Once again, these people are under oath just lying. And I'm sorry, but at this point, Lasniak is fully aware of what he's doing. Right, you got Dog the Bounty Hunter, you got At Night Media, you got Nick Casafrasu, who is also known as Nick the Hat, who is not only a YouTuber, a TikToker, an X-personality, but he is also the right hand of Dog the Bounty Hunter, a private intelligence group that works for the people, and he claims to be the head of At Night Media. So you're not you're lying when you state that you're a public or a private citizen. You are not. I sincerely hope this ends in sanctions, and I've never felt so strongly about that. At the end of the day, You know, we just have to put up with it. And then to say that because the judge did not accept their 23-minute video of me, that she did not honor the statute's requirement for a thorough consideration of the evidence needed. The fact is, you did not put any evidence on the record for months. It sat there vacant, ignoring it. You didn't respond to any of our filings. You didn't respond to anything until the ruling for the SLAP hearing was set in motion. And then on the day of the SLAP hearing, you come in talking about you don't have proof that I was served, which is ridiculous. I would be embarrassed as an attorney to say that there's no proof that I served somebody despite sending a sheriff to serve them and it's on the docket. And then when that didn't work for you, you try saying that, oh, well, wait, we haven't amended. We have a request to amend on the docket. Well, that didn't work either because you don't need the court's permission to amend after preliminary objections were put. So then you turn to, well, wait, we need discovery. You tried every which way to stall that hearing because that's exactly what a SLAP suit does. It's to waste people's time and money on baseless claims. This is textbook of what a SLAP suit is. And unfortunately, it goes on because we have no choice but to play along with these sick games. And hopefully one day, the superior courts will recognize it for what it is. And it'll become, if anything, precedent setting. So the next person that finds themselves in a similar situation or in similar litigation with these guys has something to quote and fall back on to prevent them from having to go through what we are going through. I appreciate you all being here this morning. If you haven't, will you please consider hitting the thumbs up? It means a lot. It helps. You guys are the best. Thank you for being here. Thank you all to everybody who sent a donation. It helps more than you know. But I am tired, so I gotta go. Had to cut the music for a second. I thought it would help cheer me up, but it didn't. But that's the truth. What they are doing is they're dogpiling through litigation. And unlike people who cry about mean words on the internet, I don't have a choice. I can't decide. I'm just not going to listen to that podcast or tell people, which I've always done the past year and a half, 2 years, which is don't send me this stuff. I don't have a choice to ignore. I don't have a choice to let it just go past me. I have to respond. Every time I hear a sitter, they're talking about she's being harassed, she's being bullied. I mean, even claiming that by my attorney telling me she called him as harassment. No, it's not. Having to dish out thousands of dollars to fight baseless litigation is harassment. That doesn't have a choice but a response to it. Sit over there and talk about people are taking food out of your kid's mouths and what a victim you are and how hard you have it, how afraid you are. You haven't felt anything. You don't even know what's going on in your own litigation. You don't know what is taking place. You didn't even know you filed a restraining order. You've had to do nothing but submit a document that was full of nothing but BS and put a signature on it. You have not had to deal with any other aspect of this litigation. It's no wonder you're tired of hearing about it. You've never had to deal with it. I can't wait until the judge sees all of this for exactly what it is. Because make no mistake, even if their brief gets through, even if our motion to quash doesn't get successfully accepted, there's nothing that's going to overturn the frivolousness of this filing. It will simply just make it even more important. It will go down in case record. And I'm not opposed to that idea because people need a map to follow to know that they have ways to beat people like you who have the means and the time to throw people into baseless litigation. And that's what you'll all be known as too. That's what At Night Media, Nick the Hat, Dog the Bounty Hunter, Brittany J, Julie, Betty, all of you, Christina, whoever the hell else is in it, Hung. That's what all of you will be known as. Pennsylvania's first recognized anti-SLAP, frivolous litigants. And as soon as that ends, the rest begins. So keep feeling like you're on top of the world. Keep playing little games like filing documents at 11:49 p.m. Keep acting like all of this is nothing more than a joke. But at the end of the day, all of you ruined the awareness around a missing child because your egos meant more than that child's photo being placed out of there. And not one of you to this day speak on that child because you all found a new trending topic to jump on. So you actively ruined his awareness, people's concern, people's desire to even speak the child's name. You try to actively ruin my life, barbecue's life, with frivolous allegations of RICO and predicate acts that don't even exist. And ultimately, in the long run, what you will do and what has been done is everybody, especially in Delaware County, is going to recognize that Joseph Lesniak filed the first to be recognized as a slapp lawsuit in Pennsylvania. And that is something that will never, ever leave from his name or yours. So I hope you're all happy with it at the end of the day. Thank you guys for staying. I sincerely appreciate all of you more than you know. Thank you in the Pines. Granny already won BJ. She won our hearts. She won with a competent attorney. She won the first anti-slap, and she will continue to win. I hope you're right in the Pines, and I appreciate that. I know, Angel. And then the nerve to sit over there and say, well, nobody talks about Sebastian. Well, I wonder why. I wonder why. And guess what? Everywhere I see dog in an article, I see everybody writing the truth about him underneath. That's something you will never be able to control. You thought silencing me and silencing barbecue and coming after creators over here was going to be enough to restore your reputation. And all you did was put it further in the mud because you can't silence all of us. You may successfully one day silence one or two, but you will never silence the masses, and the masses see you for who you are, which is what you see every time that screen turns black from turning off a live stream. You're faced with the reality of who you are, which is miserable, disgusting people. And nothing will ever clean that up. I'll see you all next time.